Yo, Florida employment lawyer JP coming at you. I'm going to talk today about defending non-compete and trade secret cases, which we still do, right? You can look at my YouTube channel. I have got videos on my YouTube channel going back 12 years, right? I've been in the game for a minute and I still do this stuff. So I want to give you an update and just spit on the topic of defending non-compete and trade secret cases in the year 2024, okay? I'm going to start with what's on everybody's mind, the FTC ban of non-compete agreements, okay? I've covered this in other videos. It is not a get out of jail free card, okay? Not yet, folks. At any minute, some judge in Texas who is probably a nakedly political actor is going to say, I am freezing this law. I don't think the FTC had authority to do this in spite of the plain language of the FTC Act. I'm putting this on pause because our friends in corporate America have said that they will face irreparable harm if they can't use and abuse non-compete agreements, which they use to suppress employee wages and limit competition for labor and restrict labor mobility. Oh, it sounds like irreparable harm to me, right? The emperor has no clothes. This is America, people, okay? So the FTC Act is not a get out of jail free card. You can't sit back and rely on that to protect you. It's not, right? If eventually it sticks and that becomes the law of the land, then great, it will be a get out of jail free card. But for today, it's not. So if you're facing a non-compete lawsuit, a trade secret lawsuit, okay, here's what you got to do. Step number one, where'd you get sued? Where'd you get sued? Did you get sued in state court? Did you get sued in federal court? It makes a big difference. Now, I'm not saying that federal courts are universally spectacular. What I am saying is that you'd rather be in federal court than, say, in Okaloosa County, right? Or Pinellas County, Florida State Court, right? You'd much rather be in federal court, even for whatever the problems may be with that particular federal court, even if the judges on that particular federal court aren't outstanding, okay, you still got a better chance defending the case if you're in federal court. And that's for a variety of reasons. One of the most significant reasons why you want to be in federal court, just a little show you a little law, right? I'm not just blowing smoke, okay? The standard for issuance of a preliminary injunction is regarded as higher in federal court than it is in many state courts. The movant, the plaintiff, the corporation who's trying to enforce the non-compete agreement actually has to prove irreparable harm. Beyond that, there are some state regimes like Florida where state courts in issuing an injunction aren't supposed to take into account harm to the employee or harm to the defendant, which is just preposterous, right? But in federal court, you have to do what's called the balance of harms or balance of the equities. So you get consideration there as well. So there are a bunch of different benefits to being in federal court, in addition to generally having better judges and generally having a more orderly process. Far too often, state courts devolve into kangaroo court and there are no rules. And the places, especially in Florida, state courts are frequently overrun by these state court brawlers who've been running amok in state court for 30 or 40 years. These generally tend to be men, 60s, 70s. They've learned all the dirty tricks in the book and they are politically connected. And they've just been getting away with basically, the equivalent of state court litigation murder, for the past 30 years. You don't want to deal with that. Go to federal court if you can. How do you get to federal court? We got to remove the case to federal court. How do you remove the case to federal court? Well, you got to talk to your lawyer about that, okay? You can remove the case if you have what's called diversity jurisdiction. That means the parties are citizens of different states, right? The defendant, the company, citizens of different states, and you have at least $75,000 at issue in the case. You can go up on diversity jurisdiction. Or you can sometimes get there on federal question jurisdiction if somebody sues you in state court on a federal claim, or you can get there on sometimes very novel preemption. Right? You can get there on copyright preemption, where if they're suing you for something involving a non-compete or trade secrets, but technically part of the claim they're making against you is a copyright claim, then you can remove it on preemption grounds. But you always want to look at whether or not you can remove the case to federal court. That's one. Number two, one of the things that I've seen shift over the past decade or so of doing this is that when I first started defending non-compete and trade secret cases, it goes back to the state court brawlers, right? The state court brawler strategy was file a lawsuit, get an immediate hearing on a temporary or preliminary injunction, and then run into court before the defendant, before the employee, before the other side has a chance to even get a lawyer or prepare a defense, right? Just railroad them and get a judge to rubber stamp an injunction. That's fucked up, right? That is beyond the pale, but that was the general operating strategy, right? That was the modus operandi of these fearsome non-compete enforcers from 10, 12, 15 years ago. That was their playbook, right? Run into state court, emergency injunction. You don't even have a couple days to respond. Injunction ordered, and then you're screwed, and you got to go get the judge to reverse himself or take it up on an appeal, right? You're cooked, right? That was the strategy, and it was like that for a long time. But I think courts, for whatever reason, right? They've either realized that was completely unfair and inequitable and against the letter and spirit of the law, or they've been reversed enough times, or somebody higher up has told them, hey, this is really bad form. We're not supposed to operate this way. It makes us look terrible. But there's a lot less of that, right? The judiciary, even in state court, I can't speak to all parts of the United States, and I can't speak to all corners of the state of Florida, because I'm sure there are places where that still goes down, places that are caught 20 or 30 years behind the times, right? But in most places where we practice, I see far less of that. And I'm not just talking a modest degree. I'm talking it completely fell off, right? It is the rare case now where folks will go in and aggressively seek a preliminary injunction, at least in cases in which we're involved. But maybe that's because in so many of the cases where we've been involved, we have beat people on their request for a preliminary injunction, or they've gotten the preliminary injunction, we've appealed, we've gotten it reversed on appeal, right? What are we talking, right? We got IDM Works, Evans, Vital Pharmaceuticals versus Morrow's. We got a lot of these out there, right? So maybe it's just that we beat the injunction and got the injunction flipped so many times that people, basically the landscape changed, at least in Florida, okay? So you're not seeing as many people go for an injunction. If you have to defend against an injunction, the blueprint is already out there. You can just look up some of our cases. You can look up IDM Works. You can look up the briefing that we did in Vital Pharmaceuticals. And both of those cases are in the Southern District. That'll give you a good playbook for defending against a preliminary injunction. More likely than not, on today's landscape, though, they're not going to go for an injunction. They're just going to go forward and fight and try and prove damages. So there, right, what are your options, right? What are your strategies? Okay, if you can remove to federal court, you get to federal court. If they go for an injunction, you have to defend the injunction. But now, like, we're getting into the merits here, we're really going to start cooking. You have to aggressively pursue whatever counterclaims that you may have at your disposal. Okay, and believe it or not, somebody actually bar complained me one time for talking about the importance of pursuing counterclaims when you're being hit with a non-compete lawsuit, right? So my position is, if somebody's coming at you to sue you for a non-compete and trade secrets or whatever, 90% or more of these cases are totally bogus, okay? They are absolute fabrications, companies screaming and yelling about their supposed confidential and proprietary information. Oh, you mean your customers? Yes, our customer list is so proprietary. Well, why do you post the damn list of customers on your website? Right? It's B2B. Your customers are all big companies, and you post them prominently on your website. Now you're going to go into court and say, my client has your secret customer list. And why isn't the judge laughing you out of court and sanctioning you? That's a good question. I'm just asking questions, right? Glenn Beck style. Just asking questions, right? But so if somebody's coming at you in a bogus case like this, right? Are you just going to sit back and take it? Okay? You're just going to sit there and defend the case, right? Or are you going to go on offense and say, okay, what kind of firepower do I have here? What kind of leverage do I have here? All right? And what you can fashion in terms of leverage and counterclaims, well, that really depends on the magnitude of the case and how creative you want to get, okay? Look, I tell, people, let's be real, okay? I have defended factory workers making $9 or $10 an hour for free, okay, in these cases. But I've also represented very sophisticated business folks and entrepreneurs who had 20, 30, $50 million, and they were basically like, the budget's unlimited. It is whatever it takes, right? We're fighting for 20 or $30 million, you got the playbook, do whatever you want to do, right? So it all depends on where you are, right? In that spectrum. And obviously, it's a sad reality of the system, but the more resources you have, the more capital you have, the more firepower you have, the more leverage we can get, the more offense we can acquire, the more we can turn the tables, right? And although these are big numbers, and again, right, look, the American legal system is messed up. There's an access to justice crisis. It's way too expensive, okay? Most regular folks can't afford $1,000 emergency, let alone what it would cost to hire a lawyer to litigate these types of cases. And we have to do something structurally as a society to fix that. But that's a separate topic, and I've already talked about that. I'm talking about defending these types of cases. And a lot of folks who get into these types of cases are, people who are mid-career or even senior career. They're established. They do have some money, on the side there. And it's like, hey, if this is worth fighting for, I make people all kinds of deals, right? I do flat fees. I do hybrid arrangements. But, if you have $100,000, $200,000, a lot of freaking money, okay? But if you're in one of these cases and you have $100,000, $200,000, $300,000 to deploy, right, where you're fighting over, real high stakes stuff and big money, and you're starting a business that's growing, right? Like, yeah, right. There's a difference between, kind of regular people and business people, right? And I've tried to explain that to folks before, right? I own a business. A lot of people forget that, right? They're like, well, you're a lawyer. I own a business. I own a law firm. I own a multi-million-dollar business. I have for 10 plus years. Okay, it's a business. When you're in business like that, money's just different, right? Like when you're a regular person, you're not in business. You work somewhere. You have a job. $100 is $100. When you own and run a business, $100 is not $100. It's just not the same. It's not the same. It's like $100 like a $10 bill, right? Because just the sheer numbers you're dealing with in terms of the expenses and the overhead and the investment is very different. And so if you're an entrepreneur, if you're a business person, if you're in non-compete and trade secret dispute, when you look at the cost, you're basically looking at an investment in the business. It's almost a cost of doing business. But so the more resources you have, the more leverage that you can fashion. And that is often the best strategy for getting these cases resolved, not sitting back and just getting sued and defending the case, but countersuing and really going on the offense, going on attack, right? I love it when somebody sues us, right? I don't like it when my clients get sued for non-competes, but I love the dynamic where they sue us, they think they got us cooked, and then, right, we come out of the gate breathing fire, countersue them, we want millions of dollars, right? What are the usual suspects there? Defamation, constantly, right? And I've done videos on that. I've done articles on that. A lot of times what companies do is they go out there, they still do this, right? I've talked about this for years. And if they just watch my videos or read my blogs, they might say, hey, don't do that because Pollard's going to come cook us over it. But they don't, because they think I'm just a crazy person and a bald-headed jerk-faced meanie. But you see defamation a lot, right? You see the smear campaign where somebody leaves a company, they start their own business, and then the old company is so terrified and so desperate that they go out there in the market and say, hey, Joe embezzled a bunch of money from us. He was actually fired for stealing from the company, just FYI. And so there's a whole investigation. The FBI is getting involved. You really don't want to touch him. You don't want to do business with him because you could get dragged into it too, right? That sounds preposterous. It sounds like I'm making that up, right? Bullshit. I've had that exact case. I have had that exact case where people have literally alleged that the FBI is going to get involved, right? What else do we see a lot of? Man, I see it all the time, right? Joe's going to jail. I know this because I used to be a police officer. Or I know this because my uncle was a police officer and some guy went to jail over his non-compete. Yep. Joe's going to jail. You don't want to do business with him, right? The smear campaign. I've seen every variety of that. We have run the defamation or defamation per se counterclaim at least a dozen times. That is one of the first places I look, because companies are too stupid and too desperate and too scared of hemorrhaging business, rather than look inside and say, hey, like for us to preserve this business and sort of maintain these clients who, like Joe was the primary on, we're going to have to step it up. We're going to have to put someone else good on the account. We're going to have to service those relationships. We're going to have to maintain those relationships. We're going to have to go above and beyond to keep that business. They say, no, why take any ownership or accountability, right? We could just go out there and trash Joe's name and say he's a thief and going to jail, right? Pretty clever strategy, huh? No, only clever in the short run, but a good recipe for getting yourself cooked. What else do we look at? Lanham Act, false advertising goes a similar direction, right? Just a bit broader dissemination. We also see all kinds of stuff too, right? We see tortious interference. We see fraud counterclaims, breach of contract, unpaid wage counterclaims. The list goes on and on and on, but you always have to vet that, okay? So you remove to federal court if you can. You get to federal court if you can. You get through the injunction process. You evaluate and invest in your counterclaims. And now, discovery, okay? Discovery. Anytime somebody sues you on a non-compete or trade secrets, okay? But both of them, right? Because a lot of times the non-compete is predicated on an alleged legitimate business interest in what? Confidential and proprietary information, basically trade secrets, right? So these cases often turn on two buckets of information, okay? Confidential proprietary information, trade secrets, bucket one. Bucket two is customers, customer relationships, customer data, right? Those are the two buckets. Sometimes they overlap because the company says the customer data is the trade secret. You feel me, right? But these are the two buckets of information. So once you get through these phases, okay, get into discovery, and the sooner you get here, the better, right? You have to go to the other side, the plaintiff, the company that's filing the lawsuit, and you have to force these people to identify everything pertinent to their supposed legitimate business interests, trade secrets, confidential information, customer relationships, right? This has to be extensive and incredibly aggressive, right? You're telling me that you have confidential information or trade secrets? Okay, I want to know every single piece of information that you claim is proprietary, right? Who created it? When was it created? What's it valued at? Who has licenses on it? Who's had access to it? Where is it stored? How is it maintained? How is it utilized? When has it been updated? Is there any comparable information in the marketplace that's publicly available, right? The list goes on and on. Same thing with customers, right? Who are the customers? When did you start doing business with them? How much business do you do with them? Who maintained the relationship? Who had access to that information? Are these customers locked in on an exclusive deal with you? Do they deal with other vendors and providers, right? I want the whole portfolio of information and data related to these legitimate business interests. Why? Yeah, because the emperor has no clothes. Because so many companies file these lawsuits and they make allegations about confidential information, trade secrets, protectable special customer relationships, et cetera, and their allegations are total bullshit. Their allegations are a naked fabrication. If that was a poor person or an individual plaintiff, if that was Joe Schmo plaintiff making false allegations like that, he would probably get sanctioned. His lawyer would get sanctioned. He'd get thrown out of court. But companies in America, hey, come on in, make your allegations about trade secrets, even though you can't back them up, right? That's what this is about. 95% of the time, the company is lying. The company is blowing smoke. None of this stuff is confidential. None of this stuff is proprietary, right? You get the same stuff on Google, right? You got to map that out in discovery, okay? You got to map that out in the discovery process. And then number 5, I think we're on about 5, but you want to really cook, okay? You move for an early summary judgment, right? Summary judgment is where the court can dispose of the case before trial. So you get all your ducks in a row, you get all that lined up, and you move for summary judgment, okay? That's where I see the landscape of non-compete and trade secret cases today. If you find yourself in such a case, I hope you have a good lawyer, a good law firm representing you. And if not, if you're doing it yourself, you can go through all my videos. You can go through all the blog posts on my website. You can go to SlideShare if it still exists and look at some of the pleadings that we have out there, because I have literally had multiple people contact me over the years and tell me that they were able to successfully represent themselves pro se in a non-compete and trade secret case and win using the information that I have put out there. And that's a big part of why I do this. Jonathan Pollard, Florida non-compete trade secret lawyer. Keep the faith.